Okay. Now coming to section 25. This section in any case we have done earlier as well. And now it's a quick revision of section 25. This is power of the central government to grant exemptions. So under subsection 1, the exemption is granted by way of notification. Under subsection 2, this is granted by way of special order. Okay. And then comes adding of a clarification. So this is about that. Adding of a clarification within a period of 1 year, and that will have effect as if it was a part of original order or notification. Okay. And here also we have a general exemption. General exemption comes here. No duty shall be collected if the amount of the duty leviable is equal to or less than rupees 100. So general exemption, so whether import or export doesn't make a difference if the amount of duty is not more than 100 rupees on the consignment. No duty shall be chargeable on that. That is a general exemption. So that's how the things imported by post or courier or your small parcels or gift items, those are directly delivered at home without any interference. So the amount of the duty chargeable on those is not more than rupees 100. Okay, so this we can just draw a chart. So this is section 25. And this is power of central government to allow exemptions. So this I have already added in the title. Who's there to exercise the power? The power under section 25 is exercisable by the central government. You can add further in public interest. In public interest. So another reason has been added in the title itself. Power of the central government to allow exemptions, but the exemptions are primarily for public interest. Now, this exemption can be granted in 2 ways. Under subsection 1, this is by way of notification. And under subsection 2, this is by order. So the basic difference between the two is that notification is issued in the official gazette, and that is known to all, and it is applicable to all. But in case of order, this is for a specific person, a specific situation, a specific transaction. That is the difference between this and this. So notification, this is for, or rather you can say anybody can avail. But this is subject to eligibility. So what is the eligibility for availing the exemption? That depends upon the notification. This is specific to person, transaction, purpose, period. Everything is specific in the order. This is applicable since issue, and this is applicable for the period specified in the order. Right? Now, power to allow exemption automatically includes power to modify and power to withdraw the exemption. Yes, Sukitu.
This notification government generally issues in the official gazette.
Not only generally, it is always compulsory.
Then where does it issue the order?
Order is not issued in the official gazette. It is given to the private person.
Achha, so it is 1-to-1. Order, I would say, is 1-to-1 and notification
specific,
is...
But it's specific to...
Achha, okay.
Okay.
So order would be on, application. The one who wants, let's say, some industrialist is importing something for doing some charity works in India, and he wants exemption pertaining to that consignment. So he'll make an application to the government that kindly give me exemption from customs because this is for the, let's say, upliftment of some, so he'll get the order. Okay, fine. Thank you.
Right. During the situations of big natural disasters, exemptions are granted by way of notification. Any of the charity material coming in that is free of duty, that is by way of notification. Your situation is that somebody wants to import the item for being used as a charity material. In that case, that can be done through the order. Okay. Yeah, Justin.
कोई इम्पोर्टर को अगर ये क्लेम करना है बाय ऑर्डर अंडर सेक्शन 25, तो वो पर्टिकुलर ग्रुप का एसीडीसी के थ्रू अप्रोच करेगा या वो डायरेक्ट तो मिनिस्ट्री में अप्लाई कर सकता है?
Ministry. This power is vested with the government, central government directly, the Ministry of Finance.
What would be the mode of application? वो कैसे अप्लाई करेगा इसको? जैसे एक इम्पोर्टर का कोई माल इंपोर्ट कर रहा है, उसको ये अंडर सेक्शन 25 उसको बेनिफिट लेनी है, तो what is the modus of operandi to apply for this claim?
Ministry of Finance, the indirect taxes division, make an application to them directly, and that is not a formal application. So whatever you want to write in the application, give a complete justification of why you want an exemption order.
For example, मेरा एक क्लाइंट था IIT बॉम्बे, उनको IIT बॉम्बे था, उसको जापान से एक इलेक्ट्रिक कार इंपोर्ट करना था
जी,
इलेक्ट्रिक कार इंपोर्ट करना था, और उनका पर्पस था कि इट इज फॉर रिसर्च पर्पस, इट इज नॉट फॉर ऑन द यूज ऑन द रोड। तो उनको वो इंपोर्ट करना था, तो उसमें जो ड्यूटी लग रही थी दैट इज मोर देन 100% बिकॉज इट इज दे आर इंपोर्टिंग डायरेक्टली इन द फॉर्म ऑफ कार। तो उन्होंने अप्रोच किया कि भाई मुझे इस पे वेवर लेना है, तो मैंने उनको ये सजेस्ट किया था कि आप सेक्शन 25 के तहत आप सेंट्रल मिनिस्ट्री को अप्रोच कीजिए कि ये रिसर्च पर्पस के लिए हम इंपोर्ट करना चाहते हैं, हमें वेवर दिया जाए
जी।
हाँ, तो उनका ये कहना था कि भाई हमने कभी ये किया नहीं है, तो कैसे करना है, व्हाट इज द मोडस ऑफ ऑपरेंडी।
सॉल्यूशन निकला
नहीं, वो मैंने उनको यही बोला था कि आप मिनिस्ट्री के टू अप्लाई कीजिए, फिर उन्होंने दे डिडंट कम बैक टू मी ऑन दिस सब्जेक्ट।
तो जो इनडायरेक्ट टैक्सेस विंग है उसमें आपको एप्लीकेशन देना पड़ेगा मिनिस्ट्री ऑफ फाइनेंस में, नॉट हेडेड टू एनी पर्टिकुलर ऑफिसर। ओके and it is application seeking exemption for a specific purpose. That will be the subject matter.
Okay.
And then you write in full detail. So when the application goes on the letterhead of IIT, it is going to be considered very, very favorably.
Okay.
Okay.
Okay. Thank you.
Yes, Sangeeta.
Sir, so I would like to quote it with some examples. So if I'm at the case of emergency like corona, we asked for a lot of medicines, or maybe that comes under notification. So under any natural calamity, if we require any extra products or equipments that can help if the area is hit by cyclone, that will also be under the notification, or will it be
always
also?
Notification? No, order is only for a specific person, specific transaction, specific purpose, specific period.
Okay,
right. Now your case is a natural disaster, and in that case you don't know who's going to send, who's going to import, and where the material is going to be distributed, how the things are going to be handled. then that has to be by way of notification. Because once a notification is issued, legally it is deemed to be known to all.
All right.
Order, whenever somebody wants to claim the exemption, the order, copy of order should go with the bill of entry.
Okay, understood, sir.
In this case, nothing is given except the reference of this notification. Okay. So basic thing is, this is by notification, this is by way of order. So wherever the word comes in notification, in any law, you can always add later on that this is required to be published in the official gazette. So publication comes after the issue. When it is applicable since issue, not from the date of publication. Publication will always be later. Always later. But the applicability is immediate. And what is the meaning of the term issue? Issue means it is signed by the proper authority. The person having authority to sign the exemption notification, the moment it is signed, it is deemed to have been issued. And in current scenario, when we have technology, advanced technology, within 5 seconds, whole India will know that there is an exemption notification. Isn't it? So that's how the notification is applicable immediately on issue. Now, this itself can be a question on issue or on publication. So publication will certainly come next day at least. Even if it comes as the fastest possible, it will come next day. Right. But applicability is as soon as it is issued. Then, within 1 year, since issue of notification or order, the central government may add a clarification which will have effect as if it was part of original notification or order. And last thing is, general exemption for consignment. This is amount of duty not exceeding rupees 100. So this is for consignment. Understand this very clearly. This is not per article. In the same consignment, there may be thousands of articles same time. So this is per consignment. Amount of duty not exceeding 100. What about whatever if the duty is exactly 100? Exemption is there. 101, no exemption. 99, exemption. Right. If I say below 100 rupees, naturally per bill of entry, right? But if you have more than one consignment in the bill of entry, then what? You will file separate bill of entry. Actually, this is shipment you are talking about. Okay. So section 25 is something common, and we have discussed that earlier as well. So this is general exemption that we have already spoken about. Okay. This is when the notification comes into effect, come into force on the date of issue by the central government. For publication of official gazette, so publication will always come later. Once it is issued, it is effective immediately. And when the order is effective, from which date? Applicable for the period specified in the order. From which date to which date it is given in the order. For which quantity, for which purpose, for which port or airport, everything is given in the order. So this is section 25. Not going to too much of details. Section 26 we had already done before. Rather 25A and B are remaining. Yeah. Inward processing. Goods being brought in for repairs, maintenance, processing, etc. Now, how this is different from the section 20 we talked about? In this, we are talking about the manufacturing and processing, including repairs and maintenance. So, where the central government is satisfied that it is necessary in the public interest, so to do, it may by notification exempt such of the goods which are imported for the purpose of repairs or further processing or manufacture. Condition: the goods shall be exported after repair, further processing or manufacture within a period of 1 year from the date of order of the clearance of the imported goods. Imported goods are identifiable and such condition as will be specified in the notification. Same thing is about the goods sent outside India for repair or processing or manufacture. Those can be brought in. So this is notwithstanding anything in section 20. Section 20 talks about goods being brought back and the import duty payable thereon. This is notwithstanding anything. Where the central government is satisfied it is necessary in the public interest, so to do, it may by notification exempt such of the goods which are re-imported after being exported for the purpose of repair or further processing or manufacture. So this is the common line between section 25A and 25B. In a 25A, the goods are being imported for repairs or further processing or manufacture. And in 25B, the goods are being sent outside for repairs or processing or manufacture. Only thing is that this is duty is not payable under section 20 because the goods are sent for the purpose and these conditions must be satisfied. The goods are brought back within a period of 1 year and the goods are identifiable. So these are common conditions. Right. So in this, we don't have section 20. In this, we have section 20. So repairs, processing, manufacture. This is in India and this is outside India. This is section 25A and this is section 25B. Exactly, it is re-import, re-export. But the difference is, in this case, the goods are being brought in, not necessarily those are exported from India. The goods are being imported only for the purpose of repair maintenance or only for processing or manufacture. You are getting the raw material, processing is done here and the processed goods are sent outside India. That is not re-export, that is export. But the thing is, so what is the basic exemption? Exemption is that when you bring the goods to India for carrying out the repairs or for the processing or manufacture, you don't have to pay the duty. Goods are removed under a bond, processing is done, goods are removed within a period of 1 year, goods are identifiable, other conditions satisfied, no duty is paid. That is the exemption. Exemption is that you can remove the goods for carrying out manufacture processing, provided the goods are brought in for that purpose only and goods will be exported within a period of 1 year since those are removed from the custom area and those goods are identified. Goods sent outside India, section 20 says if you send the goods outside India and then those are bringing back, then imported duty will be chargeable on that. But in this case, not that. It says goods sent outside India only for repairs or maintenance or for the purpose of processing or manufacture, duty will not be payable on those. But duty will be payable only for the value addition done outside India. Right. If identification is not there, then these provisions are not applicable. The condition is already prescribed, the goods are identifiable. Okay, so identification does not mean that it is point-to-point identification is there. You know that item X is sent and item X is necessarily a raw material for manufacture of item number Y. So when you manufacture item number Y, it has to be presumed that article which was exported has gone into the production of item number Y. Okay, so this is exception to section 20. Why this is exception to section 20? Because this begins with the lines notwithstanding anything contained in section 20. Which example, Karishma? For what do you want the example? Very simple example if I give you, iPhones are being assembled in India or not? Tell me quickly, iPhones are being assembled in India or not? Right? Where from the input is coming? Almost 100% inputs are being imported. Those are being assembled here. Right? And after that, those goods are being exported. So that comes under this category. Right? Similarly, some very good jewelry is manufactured outside India for which the goods are sent from India, like the gold. Jewelry is being imported after processing being done abroad. Then what to do? That comes under section 25B. High-tech material manufactured abroad. So we send the material, we send the drawing, we send the design, everything is sent from India and the final product is distributed back in India. That comes under this category. Okay. So in all these cases, repairs, processing, manufacture happens to be in India. In this case, repair, processing, manufacture happens to be outside India. Now the conditions are common. What are the common conditions? Common conditions. Goods are in this case returned or brought back within 1 year. Goods are identifiable. Number 3, other prescribed terms and conditions are fulfilled. So 3 conditions are common. Difference lies here. So this is exception to section 20. Section 20 says goods are sent outside India, then if those are brought back, those are chargeable at subject to duty at the same conditions as if those are other imported goods. So this becomes an exception. Goods are being exported under the bond. What the bond says? That the goods are being sent outside India for repairs or for processing or manufacture, and then no export proceeds will be realized, but the goods will be brought back within a period of 1 year. Otherwise, if we fail to get back the goods within 1 year, then what happens? Goods sent outside India for processing or manufacture, those are not returned within a period of 1 year. What happens? Then the bond can be executed, and execution of the bond means you have to realize the export proceeds. Section does not provide for extension, but in exceptional situations, extensions are allowed. Yes, Shubham.
Sir, this is related to a recent experience that came on my work. I didn't got the follow-up for that. Actually, what happened there was some machinery जो कि हमारी कंपनी ने बाहर चाइना में भेजी for services repair, and रिपेयर होने के बाद उसमें एक्चुअली एक एग्रीमेंट था, एग्रीमेंट में वारंटी टर्म्स वगैरह भी लिखी हुई थी. ऑलराइट, तो उन्होंने जो मशीन थी वो ठीक नहीं हो सकी, एंड दे सेंट अ न्यू सब्स्टिट्यूट ऑफ दैट, द अपडेटेड वर्जन ऑफ दैट मशीन. ऑलराइट, एंड दैट वाज स्पेसिफिकली मेंशन्ड इन द एग्रीमेंट आल्सो. If they will unable to fail to repair, then they will make necessary arrangements for the new machinery. लिखा हुआ था उसमें, I saw that. But when they re-imported, तो customs ने इनको क्या बोलते हैं, बिल ऑफ एंट्री में ये सब इन्होंने डिटेल में लिखा होगा. तो customs ने, I could see the bill of entry, मुझे देखने को नहीं मिला, but customs ने उन पे import duty लगा दी. So is this valid? मतलब हमने तो रिपेयर के लिए सेंड किया था. Then,
लेकिन यहाँ कंडीशन क्या दे रहे हैं? गुड्स आर आइडेंटिफाइबल. वहां से क्या आया?
दैट इज आइडेंटिफाइबल ना सर.
लेकिन वहां से तो नया चीज आ रहा है.
if same version would have also come, then
अगर सेम चीज आती है और अगर आप उसके नंबर्स और बाकी चीजें अगर आप आइडेंटिफाई नहीं करा सकते, मान लीजिए कि उसमें चेसिस नंबर है, अगर व्हीकल है फॉर एग्जांपल, right, so engine number is there, chassis number is there, some other identification number, registration number, n number are there, and if those are not matching, then this is something different. It is subject to new duty.
Okay, means even
now what should have been done? Listen, that on the new article duty will certainly be payable, no choice, but for the old article which was sent, right, you can certainly apply for duty drawback.
Okay,
so some relief can be there.
Achha.
So it is the case where the supplier is not charging you any price, but as far as customs is concerned, that is a new import. The relief available to you when the goods are returned, you can certainly claim duty drawback on that.
So it will be a new import because the serial number will be different.
Serial number is different, right? In nutshell, physical appearance may be exactly alike, but everything is different as far as the numbering is concerned or identification marks are concerned.
Barcode वगैरह वो सब change हो गया,
सब बदल जाएगा, right? तो अगर बड़ा अमाउंट हो तो certainly duty drawback पर चले जाओ.
Okay.
छोटा मोटा है तो भूल जाओ, बड़ा है तो उसको क्लेम कर लो.
Got it.
Okay. Now we move to the next section, section 26, and that we have already done, refund of export duty in certain cases. This we did yesterday only, along with section 20. So this we will not be doing again. So right now, section 26A, refund of import duty in certain cases. Refund of import duty in certain cases. So section 26A. This is refund of import duty